How to prepare for your arraignment in the state of Oklahoma. I'm Tulsa Attorney James Worth, and that is the topic that we have. You've got an arraignment coming up. The state has filed a criminal charge, or the city has filed a criminal charge against you. You've got arraignment set, and you want to know what you need to do to prepare for that. So obviously, you're going to want to have an attorney for that. That's the first thing. That's the main preparation. If you show up without an attorney, that arraignment is likely to be passed in order to give you additional time to retain an attorney unless you demand to represent yourself, in which case they do have to let you do that, but they don't want to let you do that because they know that it's going to be better for you if you do have an attorney representing your interest. Beyond that, and having an attorney, arraignments are fairly simple, but there are multiple types. So there's your initial appearance arraignment, and then there's your district court arraignment. So a district court arraignment is going to be in a felony case after your preliminary hearing. So after you've had your probable cause hearing, the preliminary hearing, they found there's sufficient evidence to bind you over for trial, then it goes to the district court arraignment at that point. Other than that, we're talking about initial appearance arraignments. Those are the arraignments that you get at the very beginning of a felony case, but also the only arraignment you're going to see in a misdemeanor case, your municipal case, or traffic tickets, those types of things. So the main thing at those arraignments is you want to get a copy of the charging document. If it's a traffic citation, that's pretty much all you're going to get is that traffic citation. If it is in district court and it's a misdemeanor felony, then you're going to have an information. You want to get a copy of that. You want to make sure that your contact information, that they put certain information about identifiers on you. You want to see if that's accurate on there, and you want to know what exactly that you're charged with. And then at that point, you're just entering a plea of not guilty. I mean, even if you are guilty, you're going to want to enter a plea of not guilty at that stage, and then you have an opportunity to negotiate later in the case to work on a deal. If you just enter a plea of guilty at that point, then you're just going to be subject to sentencing within the range of punishment. You don't want to do that. You want to get something worked out ahead of time so there's not not so much risk involved, and you know what's happening there. So there's not a lot of preparation that's required. If you have an attorney, the attorney is just going to handle it pretty much for you. You're going to stand up so the judge can recognize that you're there. The attorney is going to enter a plea of not guilty for you. The judge is going to give you a new court date for your next court date and recognize you back to that next court date. If it's a misdemeanor under state law and you have an attorney, you don't even have to appear for your arraignment. Your attorney can appear and handle the arraignment for you, which essentially is entering a plea of not guilty, getting a copy of the information, and getting that next court date. So if you're dealing with this circumstance, though, you are going to want to talk to an attorney about the facts underlying your case to get legal advice for your circumstances. To get that scheduled with an attorney at my office, you can go online to makelawEasy.com.